Good.
Good.
Good morning, everyone. I'm Chris Parker. This is Chris and Ishihara. We're at the Ishihara Parker Law Firm here in Longview, Texas, having a few difficulties this Tuesday morning, but got it figured out now. Today, we are here to talk about one of my favorite topics and one that we see all the time, those involving blended families.
What does blended family mean, though?
Yeah. So when it comes to a blended family situation, we're talking about does either parent, either part of the couple have children from outside the marriage, from before the children. You know, you may have been married for 40 years, but if one of you has a child from before marriage, you are a blended family.
Right. And it can be an estranged child. It can be a child where rights were terminated even. It just has to be a child that is outside of your marriage. That's what we're referring to as blended families. It can't be a child that you consider a child,
Yep.
right? A child that you raise, that you really consider to be yours, but if it's not your biological or legally adopted child, that is what we're referring to when we're talking about blended families today. So please apply that term as it needs to be applied.
Yeah, and if you're not sure, you should be worried because their consequences of a blended family situation can be quite surprising to the surviving spouse. For some reason, it's always us men who never handle this stuff, and eventually we see a lot of the widows coming in, and we have to deliver oftentimes some news that we don't actually want to give. So,
Right. So your last will and testament is always, always very important to have in place. But for blended families, we want to emphasize how very important and how very critical it is to have a valid will in place, and that will would need to be probated upon that spouse's death. Otherwise, what happens?
Otherwise, Texas law will write a will for your spouse and basically impose it upon the surviving spouse, right?
Right.
So husband passes away. If husband had a child from outside of marriage, what happens?
Well, let's do some hypotheticals here. But unfortunately, the surprising thing is that Texas, I think, confuses people a little bit with the community property and separate property. So a lot of times spouses just expect, well, we owned the house together. Don't I own his half if he passes away? And the answer is no. You do need to have an estate plan in place. You do need to make sure that you get that taken care of. But Chris and I wanted to run through just the most common hypotheticals that we see walk into our office all the time. So hypothetical number one.
Okay.
Let's say a husband had a child when he was young. He does not have any contact with this child. He then meets his wife, marries her, is married for 45 years. They have 3 children together. They buy a home together. They buy all of their property together. Everything that they've acquired here in Texas is considered community property because they bought it while together, while married. And then husband dies without a will. What would happen to his share of community property, Chris?
Yep, that's right. So the state of Texas writing a will or its terms on dad's estate would say everything that dad owns that's community property would pass to his children, including the child that the new wife has never met.
Right. Well, that is quite a shock to a lot of spouses to suddenly realize that maybe with an unexpected death, now they do not own 100% of the residence. They own their half of the community property, but then the half that the husband owned is now owned by his 4 kids.
That's right.
Right? So one maybe that you've never had contact with ever, don't know how to reach them, don't know how to find them. Maybe your children are still minors. That adds some complicating factors. But just an emotional time already has become super traumatic because we did not have that estate plan in place.
Right. And of course, a lot of times the spouses are like, oh my goodness, what happens? At least in that situation, they'll keep their house, they keep their half of the house. But problems arise when we hit time to sell the house, start dealing with title companies.
Right, yeah, it gets just infinitely more complicated if you have a mortgage still, because you can't refinance a mortgage and have 4 owners on the other side. They don't want to be part of the note. You can buy them out. You know, there are solutions here, but it is really, really difficult. So you want to make sure that you have had a conversation about that and you have put in place what needs to happen. Which we'll get to the solutions in just a second. But hypothetical number 2, Chris. Okay. Let's say husband has a marriage of 20 years. His wife passes away. They had 2 kids. Wife has a marriage of 15 years. She gets divorced. She has 4 kids. Okay. So second marriage, both bring kids into the marriage. And they acquire new things, but they're living in a home that the husband owned prior to marriage.
Ooh.
And then they're married, for many decades, have a happy marriage. But husband dies, and what happens at his death if there is no will in place?
Yep. So it sounds like to me that this house is husband's separate property,
Right.
acquired before marriage, and
Right.
because it's real property, I know upon his death that interest would pass to his children, subject to I think a 1/3 life estate for the spouse. But basically, his children own the house.
Right.
I mean, that is not a fun thing to tell a surviving spouse.
Right. The other complicating or interesting factor in there was his wife died.
Oh.
So his wife would have presumably owned part of that house, and at
Yeah.
her death, hopefully she had a will that was
Yeah.
probated that left him the house. But let's just make their facts easier. Let's say they were only married one time, they had kids only of the marriage, so her half of the community would have gone to husband.
Yeah.
He just brought that separate property into the marriage. But anytime someone dies, you need to investigate who owns that asset and how they own it, and then consider that. So as I just always feel for the surviving spouse in this situation, because it's usually a woman, and they are usually expecting to own 100% of the house. And so now they own either 50% or 0%, and they have invested so much time, so much love.
Sweat
they have
equity. Sweat
right. They have
equity, yeah.
put their heart and soul into building that house for their family, and now they find themselves with a limited ownership interest, and it's very hard. Especially if there's still a mortgage, and even without a mortgage, there's still property taxes and insurance and major repairs. And so when you think about investing further into that house that you are living in, you are benefiting the other owners. It's very difficult. And then the alternative is, well, do I sell and then find a new house that's independent of this? But man, what a hard time to make those choices right after losing a spouse.
All the emotional stress going on, the last thing you need to have is a housing problem, a crisis.
Yeah.
Yep.
Yeah. Okay. Hypothetical number 3. This one would actually apply to either blended families or individuals that have married one time and have kids only of that marriage. So this is really more about community and separate property rules here in Texas.
Yeah.
But let's say then that this couple was married one time, straight out of high school, and has 4 kids, all of their marriage. And wife has inherited land from her family, and so they build on that land while
Yep.
married. Wife then dies,
Mm-hmm.
and what happens to that home?
So this would be inherited property, which once again would be separate property belonging to the wife's side of the family. So unless husband wants to own it, he better have hoped there's a will that he's in favor of. Wife leaves everything to husband. Otherwise, it's going to be going to her children
Right.
or their children, but
Right.
skipping him.
Right. So community and separate property is something to really understand as well. Community is presumed if property is purchased during marriage. If property is, and so usually when we talk about this distinction, it matters most for real property, land, home, but separate property is either owned before marriage. I'll give you a good example of this. I bought my house here in Longview before Rich and I were married, so my house was separate property.
Mm-hmm. Mm-hmm.
Then gifted property. So if someone gifts you property, usually that would be a family member,
Right.
or inherited property. Those are all separate properties, separately held. That matters in 2 types of law in Texas. 1, if you get divorced, but 2, when you die. If you don't have a will that covers all of that property, then that has different rules under the intestacy laws of Texas.
All right, so there's 2 parts to this. 1, we know our loved one needs to get a will done, because if they don't, Texas will write a will for them and is not in favor of the surviving spouse.
Right.
Okay, I mean, I think that's
Right.
fair to say. So number 1 step is you get a will. So let's say I paid attention to this podcast. I thought, my goodness, I'm that situation. I will be half as rich as I thought I was if my spouse passes away. I need to take care of business. I go talk to my spouse. My spouse says, yes, let's get it done. We come in. We get this will done. We get it written up. It's 30 pages long. We feel great. We feel wonderful. We take it home. And of course, fast forward 20 years, husband passes away. End of the story.
No, so you need both a valid will. So we've done some podcasts on that, how to have a valid will, an intested will, or a holographic will. So you need a valid will. that indicates what the decedent's wishes are, and then you do need to probate that will within 4 years of death. A non-probated will does not transfer title. It has no legal effect on any of your stuff. So it does need to be probated within 4 years.
Yep. So let's be clear. You get the will done, you've done half the story, half the battle. You have to complete it by probating the will within 4 years of the date of death. That will, you need to take it to an attorney and have them give you advice on whether to probate it or not. I can tell you right now, in a blended family where you are the beneficiary, my general suggestion is to probate.
Sure. Yeah, there'd really be no reason not to. And, you know, I think sometimes what complicates this is just the general, you know, hesitancy to get a will done. So people don't like to talk about it. They don't want to think about it. But then when you add the blended family, sometimes it's just hard to make those decisions, right? We've kind of talked about this so far, assuming that the spouse that passed away would want to leave everything to the surviving spouse, and maybe that's not true.
Right. Right. But the answer is this. So either you talk to your spouse, and of course you need to get your power of attorneys done, which we'll talk in another time, but you're talking about the will specifically. Either your spouse wants to leave you everything, and the only way for that to happen is to do the will, or your spouse wants to leave things to his children, which will happen when he refuses to cooperate in the process of doing a will. I mean,
Right.
you need to know how wealthy you are. You need to know what you're going to own. It might affect your retirement. It might affect where you live. I mean, there's all many factors.
Yeah, well, we just want you to make a decision that has been talked about and understood. So at the end of the day, you each own what you own, and you get to decide where it goes at death. But you can have different decisions, so it's not just all or nothing, right? So I could have a will that says I leave my residence or any interest in it to my spouse, but I leave everything else that I own to my kids. I could say I leave my inherited farm property that came from my family to just my kids. I leave everything else to my spouse. I leave the business that I've built with my child that's been in my family for decades. I leave all of that ownership interest to my kids. I leave everything else to my spouse. So just talking about and having those conversations is so important, and it helps you work through any holes. So if I'm leaving my house to my spouse, but there's a mortgage on it, well, maybe I need to add some life insurance so that if I passed away, now my spouse is not left trying to figure that out. But then I leave everything else to my kids. We don't care what your wishes are. You get to decide that, but we do want to make sure that couples have an understanding of where their assets will go and how they can make sure they go where they want them to go.
Setting expectations. I mean, I have seen complicated family situations that have worked out wonderfully because mom and dad sat down, worked out a plan that they wanted to happen, and then told the children, this is what will happen. And those families have been able to handle what would many times have been very complicated, expensive processes, handle it smoothly because mom and dad said, you know what, we're taking care of it early, we're laying down the law, this is what will happen. And then everybody went into that expectations of this will happen for the next 30 or 40 years, and there was no problems at all.
Right.
The ones that I see are problems are the folks who don't have those discussions. They wait too long, or they ambush the adult children, and then things can get messy.
Right. Well, what's the, saying not doing anything is making a decision?
That's right.
Right. So, having to drag the spouse in to talk about these things is something that you need to really apply yourself to get done. They do call attorneys counselors. We do end up helping you kind of walk through this. We can't make a decision for you, but we can probably offer some alternatives so that everybody can be happy about what the plan is. But the plan needs to be on the table. It needs to be understood. And if your spouse doesn't want to leave you anything, that's something you should know because you would need to make decisions related to that in probably your everyday life.
And I know we're talking about blended families with regards to inheritance, but I just want to throw this out as well. Maybe this will help convince your spouse to come in. I always think of end-of-life things. Your loved one's down at the hospital. You've been told bad news, and you are making a decision for your spouse to pass away. And then those adult children come running into the room and say, hey, why are you killing dad? Right? That's where those power of attorneys come in on blended situations. You may have a great relationship with those stepkids, but fast forward it a number of years and add in death, and things can get tricky. And that's why I, of course, veering back to powers of attorney as to get someone in, like, let's get those powers of attorney done so your wishes can be met. And while we're here, by the way, what do you want to happen to your stuff? because everyone needs to know the plan or the state of Texas will impose one.
Right. And making sure that that's part of your holistic comprehensive plan, because a joint owner on a bank account will trump the will. A beneficiary listed on life insurance or a retirement account will trump what your will says. So making sure that you have those things complete in the way that they need to be, and talking through those things. You know, what is top priority? Is it providing for spouse at all costs? Is it making sure that I get something to my kids at my death, even if I die before spouse? And that may change with the season of your life, right? So depending upon, you know, your current financial status, you may have different answers to that, and you may need to adjust that as you age and get closer to retirement.
Yep. Do we want to talk about any other plans or stick with wills?
You talk about other plans.
All right. So if someone comes in and they're a classical blended family, at least one child from before marriage by one of the parents, we've talked about wills. What is a more advanced, I'd say it's more advanced method in which you could handle estate planning?
Sure. So, you know, just basic level estate plan, you need your financial and medical power of attorney, HIPAA, directive, and a last will and testament. And I try to tell every client who comes to my office, if they are signing a will with me, whether I anticipate they will need to probate that will. So if there is a blended family, then I will tell them as they're signing the will, this will need to be probated at your death. And I think attorneys don't do a great job usually of communicating that, because people sign the will, they think they're done. Sometimes they call our office and say, well, I had a will done. Doesn't that mean I don't probate? No, having a will means that you will probate. That's the decision that you've made. So the alternative estate plan is using something called a revocable family living trust. It's an alternative to having a will as your estate plan that would be probated to pass your assets at death. So blended family is a great option for that trust, because we know that you're going to probate probably at one spouse's death and probably at the second spouse's death. So when you look at, usually people want to balance cost. I understand. When you look at it, the costs are about the same. They just happen at different times. With a will, you pay the attorney to create the will. Then you pay an attorney to probate one spouse's will. Then you probate the second spouse's will, and you've paid all three of those times. So having a revocable living trust is an alternative where you avoid probate, because you essentially set up your estate while you're alive.
In other words, when we set up the trust, just generally speaking, the assets go in the trust terms control. It generally says from us to the survivor, and then from to the survivor to the heirs, however we've listed it. Outside of probate, which can be a seamless or more seamless process, less court involvement, less interaction or opinions from the heirs. It's definitely a speedier and more private process.
Sure.
So.
And that's really just personal preference. So we talk about those options when we meet with clients, and we just, you know, give them the options and allow them to decide the way that they want to set it up.
Of the people that I see coming in with, I would say, problems, obviously we do long-term care, nursing home and things, but among the estate planning issues I see, I would say blended family, surviving spouses are those that I have to deliver the most bad news to people who are not prepared for it.
Yeah, I agree. It usually comes up when surviving spouse has gone to sell the house and the title company has asked for the stepchildren's information, and she says, why do you need that? And it's a surprise at that time that they own half the house. You know, so sometimes that spouse has a will that has not yet been probated yet, and we're able to help, and then that's, you know, a happy resolution that she owns the house now and is able to sell it. But sometimes the answer is, well, you don't own half of the house.
Yeah.
And that's an unfortunate thing to share with a surviving spouse. So times that this is really important is if you or your spouse have a child outside of your marriage, you need to get your will in place. If you or your spouse have any separate real property that was owned before marriage, gifted during marriage, inherited during marriage, or before marriage, then those are times when you really need to make sure that you have a will in place so you understand where, it's just the residence is so important. Where that residence will go, where other land will go to, but the residence is really just, we just want to make sure you have your house and it's going to be yours when somebody passes away.
Golly, please probate it.
Right.
Please probate that will.
You have to have a valid will that says where it goes. You have to probate it within 4 years of death, or have another estate planning tool that would allow it to transition to you at spouse's death. So anything else you want to add?
That's it.
All right. Well, thanks, guys, for joining us. We'll be back with more interesting topics next week.